So today we have a great Real Estate Friday. We have a guest speaker, which you will meet very soon. Her name is Nicole Martens from the Martens Law Firm. She's going to be talking about probate, a referral source, and a deal breaker. So it's really interesting. And then after that, we're going to give you guys some updates as to some addendum that came out in regards to COVID-19. So stay tuned for that, because it's going to be a really interesting Real Estate Friday. So I think it's 1:02. We have about almost 30 people sign up already. So let's go ahead and start. As I was saying, I want to welcome everybody to Real Estate Friday. Every Friday, every day actually, we do have trainings like this, where we come to you with information as well. If you're signing up for the first time to us, to this type of Zoom meetings, every day we have trainings like this. So if you're joining for the first time, go to BrokerNation.events and you see a list of different type of topics, trainings, updates that we're giving out to our agents. So feel free to always join us, and for the latest information and suggestions, tips on what to do in today's market to be able to continue moving forward and continue producing and growing your business. So I want to introduce to you Nicole Martens from the Martens Law Firm. She's going to be talking to you about probate. How many of you have dealt with probate before? You can raise your hand, wave. Anybody? Well, probate can be a great source of lead generation. Some of you have dealt with in the past. Maybe it went well, maybe not. But probate can open the doors to a lot of business. So, and Nicole is going to be talking a little bit about that. So the topic today is probate, a referral source, and a deal breaker. So I want to give the floor to Nicole Martens. Hi, Nicole.
Hi, Dylan. Thank you so much for having me. That's the first order of business is that. Thank you for allowing me to be a part of your guys' group today. I'm excited to be here, and I hope that I provide something of value to you guys. So first and foremost, my name is Nicole Martens. Like you said, I am the founder and owner of the Martens Law Firm, and I practice primarily in probate and estate planning and asset protection. So I'm going to talk to you guys a little bit about what that is, what that means, and how it relates to you and what you guys do. But just by a way of background, a little bit of context on me before I dived into specifically estate planning in a former life, I'd like to say. I was actually a trial attorney representing multinational corporations in really big trials in all aspects of litigation. I did trials for Philip.
It's freezing on us.
Oh no. Any better now?
Oh, I can hear you perfectly.
Okay, great. So that's probably the most important. I'm not as interesting to look at, maybe better to hear anyways. I used to be a trial attorney, and I represented some multinational corporations in all phases of litigation through trial, some cases that were worth 55 million, 30 million bucks, some really complex stuff. And I started doing estate planning for the executives of these companies, and then ended up liking that way more than the litigation lifestyle. So I transitioned full time into that. And so here I am. Own my own firm and handle a lot of matters and work closely with realtors, in fact, on different issues. So before we get started, let me just give you some background on what probate is and how it overlaps into your guys' world. So probate is really any kind of asset, typically real property that's only titled in one person's name and that person passes. And actually, let me just back up 1 second. The thing I forgot to say is that probate involves the topic of death. So I hope that it's not a trigger point for anyone, and I try to be as sensitive as possible when I talk about these things. But I also try to inject a little bit of humor to lighten the mood, because if not, we'll all leave here relatively depressed. So bear with me. I'm not being insensitive. I'm just trying to bring a little bit of lightness to the subject, all right? So with that being said, probate, we talk a lot about people who pass, and when they pass, how they leave their properties behind and how that affects the people that are inheriting. And then you guys, by contrast, on when you're trying to represent the buyer or seller and you find out that the person who's on the title, or even one of the people on the title, is dead, what do you do? So that's it. It has to go through its own court process, which is called a probate process. And it's lengthy and time consuming. In Dade County, it typically takes anywhere from 12 to 16 months to probate an estate. Nowadays, it's longer. So 2 weeks ago, we had a Zoom conference with the probate judges and the attorneys that practice in this area. As you may or may not know, but courts are closed halfway through May, and that is going to create a huge backlog on cases being heard. So judges and their staff are working remotely, doing as much as they can from home, but they just don't have the ability to do everything that they're able to do in the courthouse. So we can anticipate that the probate process now will likely take much longer than the 12 to 16 months that it currently was at before this whole COVID situation. So when we talk about probate and how you guys get involved, really, it's virtually pretty simple. You represent someone who is either trying to buy or sell a property. And when you guys come to that moment of actual purchase or sale, it comes up, well, actually, this property was my mom's or my grandmother's or whoever's, and they just died, or they died a year ago or 2 ago, and nothing was ever done with the title. Well, by law, that person who's now, inheriting that property, whether it's by a will or not, they can't just purchase or sell. They have to have some kind of document that transfers, right, the property to their name. So that would be the probate process. So the probate process essentially would allow the beneficiary, whether it's the child or whoever, to legally be entitled to do whatever he or she wants with the property. And you have to have a personal representative appointed, the personal representative that has to get an order from the judge allowing him or her to move forward with the sale or purchase of the property, or even just to put it in his or her name. So when we talk about you guys representing someone, the most important thing is upfront to understand who it is that you're representing. And a good rule of thumb is, who am I speaking for and who am I advocating for? So if your client is someone who comes to you and says, oh, I got this property from my grandmother, you should ask more questions. Is your grandmother still alive? How did you get it from her? And the quicker you guys get involved, the quicker that you're able to, get your arms around, I guess, the facts of the situation, the quicker an attorney or someone can help you guys navigate that probate process. We can't wave a magic wand and make things happen magically, but certainly, we can help guide you and hopefully point you in a direction in which makes the process shorter and it doesn't affect your deal. So this happens a lot. Like I said, I work with realtors, and it's come up where people come to me and say, I was, representing the buyer or the seller, and it turns out that the property's in someone's name who's no longer alive. What do I do? And then my questions start, which are questions you can ask too. Was there a will? And in that will, is there a person named as a personal representative? Or is there a specific person who is named as the beneficiary of a particular property? And it can get really hairy. And I'll give you an example. I have a client that called me last week saying that the grandmother died but left a will. I said, okay, that's great. She only has one property, the client said. I said, okay, that's great. So who is the property left to? So I'll use a fake name. It was left to Joan Smith. Okay, that's great. Except there's 5 Joan Smiths in the family with different variations of last names, like Joan Smith Martinez, Joan Smith Campos, whatever. So that's a problem. We have to figure out who this person intended the one Joan Smith in the family to be. And luckily, they came to me before they wanted to sell the property, before they were in any kind of real estate transaction, so to speak. And so we're able to hopefully get that fixed relatively quickly. That's an administrative thing that probably won't require a full probate to be open, so we should be able to get that taken care of really quickly. So I guess that's the first point of order of matters, is to figure out the person that you're speaking on behalf of, right? Your client, whoever that is. Are we dealing with a property that is being given, whether by will or in testacy laws? How is it being given to them, and does it involve the death of someone? The other thing to take into consideration is to get some background information about the heirs, right? So if grandma left it to one grandson, but she's got 4 grandchildren, are they going to try to contest it? Are they at least have to be notified of the process, right? Not that is your work to do, but the more information you have, the more you can understand if this is going to be a simple or a hairy situation, really. the hairier it is, the longer it might take, the more difficult it might be, but the quicker you should get engaged with someone who can help you guys navigate the process and keep you close to the process, so that when the judge's order comes out, says, okay, great, now we have a personal representative. We know that the heir to this property is John Smith, and great, now John Smith can buy and sell, encumber, and do whatever he wants with that property. Fantastic. Then you guys are still around. You're still the person that we're turning to, or that the client is turning to effectuate the transfer, the deal, the sale, whatever it might be. So, out of sight, out of mind. This comes up, the last thing you want to do is just point them in the right direction to who can help them. You want to be that, I would say, that bridge right between the legal counsel and their representation as their realtor. So that's one way in which I work with realtors.
Nicole.
Yes.
Hi, I have a quick question for you. When you said the personal
Sure.
representative needs an order from the judge, can you go into a little bit about, what that process is and how long it typically takes, bar, the situation that we're in right now?
Yeah. So the process of having a personal representative named isn't necessarily what takes the longest, right? What can take longer than that? So let me just back up a little bit. Let's say you're dealing with a client who's inheriting a property through a will, and they're trying to sell the property, but it's not in their name, so they can't legally do that yet. We would have to petition for probate. That's the first step. That's something an attorney would do, is just petition the estate for probate. And we would create an estate for this person, for the deceased person, right? And the process of probate is really to transfer the property into the new person's name. That's really what the process of probate is. It's just, there's several steps to go through in order to make that happen. So if there's a will, it typically will name the personal representative, and nominating, getting that person officially appointed, we'll call it, and like an order saying, okay, Maria Smith is now the personal representative of the estate. That happens relatively quickly. Once we have that, we can then petition the judge before the probate is over and say, okay, now that we've determined who the PR, the personal representative is, and now that we've determined that the property is going to the sister, we need to sell this for whatever reason, right? We're not going to live in it. We don't want it as an investment. It doesn't matter what the reason is. So you don't have to necessarily wait until the process is over to effectuate that sale, but we have to have typically a personal representative and an order allowing the sale. Now, that being said, that can take, I've seen it take as little as 2 months, sometimes just 3 to 4 weeks if you're lucky, and sometimes much, much longer than that, 6 months. It just depends, and it depends on the facts of the situation, which is why I kind of touched on beneficiaries and heirs, right? Let's say, even though the will nominates, I'm just going to say the granddaughter as the personal representative, if there's another granddaughter who decides to contest it and say, you know what, judge, I don't think that's the best option for that granddaughter to be it, because she is a drug addict and she's probably going to steal any assets that she gets from the estate, or any kind of conflict. That has to be heard if it's brought up, and all of that can stall the process. That's not uncommon. The drug situation is not a common situation, but it's not uncommon that the PR is contested. Sometimes there's no issue in families, and sometimes there's a lot. So it's hard to answer your question. But what I would say is that, I guess in a perfect world, it could be as little as 6 weeks. It could be as long as several months, depending on the fact pattern that we have and the family dynamics, really. Does that answer your question?
Pretty much so. Is the PR actually the same as the trustee?
So the trustee would typically be someone who manages the assets of a trust. The personal representative is not necessarily the same. If we have someone who has a will and a trust, those are typically the same people, but they don't necessarily have to be the same people. So an individual can name personal representatives to their will, and then they can name separately trustees to their trust.
And so if there's a trustee, say there's a trust that was established before the person died, and a trustee was assigned, can that trustee then choose the personal representative, the attorney that's going to be handling the probate?
It depends if there's a clause in the trust agreement allowing that.
Okay. That's good to know.
It could be that there could be discretion there provided. What I see commonly is that a will nominate personal representatives that are close in degree of relative, right? So I don't know if that's the right expression, but like a spouse, a sibling, a child, something like that, who is also geographically close to wherever the majority of the assets are. And the trustee doesn't necessarily fit that bill. It certainly can, but doesn't necessarily fit that bill. So it really depends on a lot of different factors, but they do not have to be the same person. And the trustee can name the PR if there's a provision in the trust that allows it.
Okay, thanks, Nicole.
No problem. What was your name?
Jane.
Jane.
Zimmer. Mm-hmm.
Great question. Thanks, Jane.
Mm-hmm.
So there's a level of legal knowledge that really to set the foundation to help you guys understand the entire context. And what Jane was asking about is a trust, which is something that is different than a will. So just as a way of background to make sure that the framework, I guess, is set, and perhaps I should have done that to begin with, although it wasn't really something I intended to talk about, but the will is essentially a document that will explain to people or to a court how they want their assets to be distributed when they pass, right? So let's say a single man owns a property, but he has 2 kids and a couple of bank accounts. And he says, when I pass, I want all of my assets to go 50-50 to my kids. And he has that in his will. That's great. No one can intervene and say, hey, I want 10% because I'm going to be watching your minor kids. And nothing happens except for the division that was requested. The only issue is that the will does not avoid the probate process. So that's the biggest con in this situation, I would say. And I also forgot to mention, I have 2 little kids, and like the rest of the world, I'm working from home. So you might hear little voices in the background. Earlier today, my 3-year-old jumped in my video and announced that she was the big bad wolf pounding on my desk. So I have a big bad wolf in the house. You guys might hear her. Yeah. The trust, by contrast, so it also deals with how to distribute your assets, but in a much more flexible way. You can put all kinds of conditions on the trust and provisions saying, my kids can only inherit if they graduate from college, if they're not on drugs, if they, marry someone of the same faith. I mean, you could put almost any provision in a trust, and it's a lot more flexible. But it avoids the probate process. So there's no need to go through the probate process. All the transfer of the assets are done through any estate planning attorney, really. And it's a matter of however long it takes the beneficiaries to come to the attorney's office and prepare the paperwork. So there's no court involved whatsoever. So that's the biggest difference between the will and the trust. How realtors are benefited by probate attorneys. So this is actually really exciting to me. So as an attorney, I'm always looking for ways and figuring out, and I think probably much like what you guys do, is where do you capture your audience? Who is your target audience, number one? And then where do you find them? Where do you find your potential clients? And you try to figure out, if you know who your potential client is, what's their lifestyle? So where are they working? Where are they shopping? Where are they doing leisurely activities? Who do they associate with? So service providers in all of those areas are who the people you want to be around and getting to know, so that they can refer you who your potential client is. So much like what you guys probably already do, I do a lot of the same kind of thinking, right? My ideal client is, and I'm just going to make it up, this isn't necessarily the ideal client, but my ideal client is a couple with minor children who have at least 1 property and 1 business. So where would I find relatively young families that have property, that own their property, and young kids? Well, preschools, right? Elementary schools. They're certainly going to have their kids somewhere. What do the preschool and elementary schools like to do? So slime is a huge thing nowadays. So great. Where do we have slime parties? Who hosts those? Mom groups. There's a slew of different services that are catered to whatever your target audience is. And then I try to figure out where my target audience hangs out, what they do, what they like, and try to capitalize on those different areas. But one of the things that never really occurred to me until maybe a year and a half ago was you guys, realtors. So I was working with a client, and he said to me, I specialize in probate properties that are in foreclosure. So not all properties, by the way, that are in probate are in foreclosure. A lot of them are just someone assumes the mortgage, whether it's a spouse, a child, a grandchild, they assume the mortgage, or there's no mortgage. So it's not necessarily that a property that's in probate is getting foreclosed on. And what I find interesting is that there's so many different niches in so many different fields that I'm constantly learning. So there is someone out there who's a realtor who specializes in foreclosure properties that are in probate, which is very, very specific. So who does that guy want to hang out with? He wants to hang out with the probate lawyers all day long so that when properties come up for sale, we don't list it. You know, we talk to them directly and say, hey, we have a connection already. And we say, hey, this property came up and I don't necessarily need to list it. Do you have someone that's interested? So that I found to be valuable. So now what I've done is I've done a lot of what I'm doing with you guys in person really is speaking to different realtors to educate them about the probate process and how it can be beneficial to them. So I'm one of a million, right? You can find probate lawyers here in South Florida, a dime a dozen. And so I challenge you to find someone that you might have a mutual contact with that has a contact with a probate attorney and get to know them. Get to know them so that when something comes up, you're their first go-to or at least on their list of options, and you can get your clients in front of these people without having to deal with you know, a lot of red tape, right? And so in the probate process, despite the probate process itself taking a long time, sales within the probate are people try to move them along much quicker because there are people, either they know right off the bat, the beneficiary, I don't want this property, I don't need it, therefore I don't want to continue paying for it, so I want to get rid of it really quick. And it's true that they say, right, if you didn't work for something, it's easier to get rid of it. So they're more motivated, I find, than typical buyers to get rid of their properties. I have a gentleman who's constantly reaching out to me. I don't even know, actually I do know, he found me on Instagram. And I would say borderline stalked me, but not in a creepy way, just professionally stalked me to ask me every couple of weeks, hey, any new properties come up, any new properties? So his clients are all foreign investors and they want to buy cheap properties as quick as possible. And they trust this guy to point him in the right direction. This guy wants me to be his go-to person. I said, listen, I already know Dylan and his team, like you can't be my go-to person. So I've got someone in line ahead of you, all right? But truth be told is, you know, if Dylan doesn't have someone or no one's interested for my first option, I got to go to someone else, right? So he's trying to be at least my second option right now. And I think that that's great for you guys. It's the same, it serves the same purpose. So if there's anyone out there that you have a connection to, and if you don't, make a connection, try to make a connection with someone who has a probate practice so that you can be top of their mind. And when opportunities come up, they really just fall in your lap and will likely be moved quickly. And you know, you look like a superstar to your client. Hey, listen, you're going to be the first person to see this, to even know about the property, whatever it might be. I think that that is a really beneficial relationship, one that honestly never even occurred to me until, like I said, a year and a half ago. And then when I figured out that, hey, there's a lot of foreign investors, which are actually my ideal clients. I forgot to mention at the beginning, I look totally American and sound American, but I actually am Brazilian. My parents are Brazilian. I grew up in Brazil and I speak Portuguese fluently and pretty decent Spanish. And so most of my clients are actually Brazilian. And so I have a number of different Brazilian people that refer their clients to me, and foreign investors are huge. So the Brazilian investors come here and they want to purchase property. And I said, that's great. So from an estate planning standpoint, they have to know a few things. And I always tell this to realtors because I've gotten so many people, none from your team, Dylan, okay? None from you guys, but I've gotten so many people that come to me and say, oh, but I heard that if I put my property in an LLC, I don't have to pay taxes. I'm like, oh my gosh, who told you that? My realtor. I said, no. It doesn't work like that. So realtors, I say, they buy and sell and they help you do all the real estate stuff. But lawyers help you decide, you know, what and how to minimize taxes and that kind of a thing. So here's a really quick lesson for anyone who's got foreign investor clients. Foreign investors, if they do not have fiscal presence, if they're not a fiscal resident, that doesn't mean they have to have a green card. They just have to have fiscal residency, which is a legal term that I can't even begin to describe because I'm not IRS and I'm not CPA certified. I'm not an accountant, but essentially their exemption is only $60,000. So if they're not a resident or a citizen, let's just say, and they purchase a property for $500,000 and they pass, they get $60,000 worth of that property free of taxes, right? That's their estate exemption in the state of Florida. The rest, they can pay up to 40% in taxes. That's a high number. So when I deal with the foreign investors, it's the first thing I'm telling them. And by the way, if you don't have a trust, you also have to go through the probate process for that property, which is really expensive. So number one, we want to put the property in a trust to protect and get away from the probate process, so we save them money that way. Number two, we can create an LLC to own the entity, to own the property. It doesn't make the tax, like that foreign tax person, go away, but we can, what I say, we kick the can down the road. So if we structure the operating agreement properly, we can avoid when the owner passes paying tax, but we kick it to the next generation, basically. So there are planning ways to get around it. Now, by contrast, if you're a resident or a citizen and you purchase, or not purchase, but you have assets that total, for individuals, it's 11.5 million. For couples, it's about $23 million. So if your clients have assets, and let's talk about real property. If they have real property that is less than the 11.5 million for individuals or 23 million for married couples, they don't pay estate taxes. Florida follows the federal rule. That means that the federal government has listed these amounts, right? I didn't create them. It's 11.5 million and 23 million, and Florida follows the federal rule. So if your estate tax, or if your estate is made up of properties worth 11.5 million or less than 11.5 million, there's no estate taxes. Of course, you still have to pay the taxes on the properties, guys, right? And there's no such thing as creating a trust. My Brazilian clients, I can say this because I'm Brazilian, always think that there's a way around paying taxes. I've said, my friends, two things guaranteed, you guys already know what it is, right? Death and taxes. And we can minimize your estate taxes. We can minimize certain things, but there's no avoiding them altogether. And we cannot create a trust to avoid doing anything. It just doesn't exist, right? So the biggest example I give is if you mortgage a property and you put that property into a trust, and for whatever reason you stop paying the mortgage, you get sick, you don't have the money, COVID happens, whatever, the bank can penetrate that trust and take that house right away from you. So it's not because it's in the trust that it makes it impenetrable and untouchable, but there are ways to structure it to protect it. And asset protection is a real thing. It's something that I work on closely with the real estate investors, and setting it up in a way that really makes it airtight so that if you are sued, nobody can penetrate your assets and the other properties that you have, if you have one or more than one. So that was a mouthful. Does anyone have any questions up until this point?
You don't need to drink some water? That was
Not yet. Not yet.
So that was perfect. I think your explanation so far, you have covered what I've seen. It's what is a probate? When will the probate affect our deals? The process, the timeline you went over a little bit of, how long it could take. What do we need to know to be able to close the deal, and how to avoid it if at all possible. So
tell your clients to get trusts. That's the best way.
I talked about building, especially now that we're home, that we're in quarantine. I talked about that it's crucial to build a team around us. Now is the best time to do that. Having a connection with the mortgage broker, having a connection with the bank, having a connection with professionals. In this case, with somebody that's gonna help us, and like you, that can help us getting out of a situation like a probate. Or now we can offer our clients a service that, ways that they can not only protect their assets, but if something happens and, God forbid, because of the situation right now, a lot of people are being affected by it. So it's good for them to be protected. So it's a good way of providing you that service as well, by talking to our clients, letting them know there's a solution to the problem of dealing with probate, and then we can send them your way. Would you like to give your information? How can we reach you?
Sure. You can reach me at 305-699-2646. No, I'll put it in the chat. I'll provide my email, my phone number, and my social media handle.
So in case somebody wants to talk to you, like the other guy, what's your Instagram?
It is the Martens Law Firm.
Perfect.
Thank you. The last thing I wanted to leave you guys with that is not really related to probate, but I think is really relevant to the time period that we're in now. So a lot, and I'm sure you guys have gotten these calls too, colleagues calling to basically vent and say how they've been affected and how business is down and how everything sucks and nobody's making money and this, you know, the apocalypse is upon us, and all of that may or may not be true, but I'm a huge believer that a lot of that is in your mind, and what you look for, you find. So if you're looking for excuses to not do well, you'll find them. And if you look for excuses to do well and rise above, you will. And there's plenty of time and plenty of money to be made, even in this economy, even in this, unheard of pandemic and time that we're living. So Grey Goose, the company Grey Goose, was founded by a man who was 72 years old. KFC was started by a man 62, Harlan Sanders. Home Depot was opened by a man in his 50s, right? The Huffington Post was created by Ariana Huffington when she was 55 years old. So people, we've got time. What we need is grit. And we talk a lot about when one door closes, another one opens, but in between that corridor is a witch. And people don't talk about their corridor stories enough. So I want to encourage you guys to get out there, be gritty. You've got time. You've got time. Be gritty, be tenacious, and share your corridor story when that time comes. Because I think too many times we focus on the door that's closed or the door that's open, but the in between really matters, and it really shows us who we're made of. So I want to wish you guys all the very, very best. Thank you so much for having me again. And I hope that our paths cross in person at some time in the future when all the social distancing is over. Thank you again, Dylan, for having me.
Thank you, Nicole. And that was very well said. Thank you so much for sharing your information. Appreciate that.
Thank you. Take care, guys.
Thank you.
So that was excellent information that she just
you.
provided. And it's good to know because you never know what kind of situation we can fall in with one of our clients, especially now. Things are happening, and when we're dealing with a client, we want to give them the best solution. So getting to know people like Nicole and surrounding ourselves with professionals can definitely help us out with this. Now, we have some updates that we want to share with you, and I want to give now the mic to Marta Pozo. She wanted to share with us some information. Marta Pozo, as you know, and she's our in-house title and legal services, so she can definitely help you out if you have any questions regarding title or any legal issues. Marta.
Thank you, Dailang, and thank you, Nicole. I really liked your presentation. What's wonderful about all these meetings that I attend and that I listen to is that you always learn something. You always learn something, and I think the information you provided is very timely and very, very important for everyone that handles real estate transaction in today's. And I will keep your name because I do run into some probate issues and I don't handle that. So thank you. I like your statement. Let's look for the positive and no excuses. If you remember Franklin Roosevelt, he ran for office and he was paralyzed from the waist down and he still became the president of the United States. So there's a lot of stories out there. There's a lot of people who have triumphed over adversity. So, I know that, there's closings going on. Today I was very blessed. Yesterday I had a closing. Today I have 2 other closings. So I'm in the office. People are coming, people are closing. So I can give you guys that hope, because I really believe that I have the pulse. I'm at the pulse of what's happening in the real estate transaction. I know you guys are also, because you guys are getting calls and you guys are showing and you guys are getting contracts. But I can tell you that I am getting contracts. The contracts are closing, the banks are lending, and the transactions are still out there. So if you guys are in a rut, stop looking down that tunnel and get out of it and go outside, and I'll tell you that there are closings happening. Yesterday I sent out an email to all the Broker Nation realtors sending with an attachment of the new COVID rider. It's not a rider, it's an in-person acknowledgement. I'm gonna share my screen so you guys can see it. Hold on one second. Okay. So this is a, you know, I really do need to hand it to Florida Realtors. They're really they're really sending out very good information when it comes to COVID and the day-by-day issues that are being faced by realtors. So this document is to be used when when you as the listing broker or the cooperating broker are showing the property. Okay, and so the way you fill it out is you choose if you're the listing or the cooperating broker, and this notice is going to be given, you know, it's going to be given to each prospect that you're going to show the property to. And it's basically just an acknowledgement of the risks that are, you know, that are being posed by the COVID. And it's like a release for these showings and these inspections on the property. I don't know if, I don't want to sit here and go through this form, but I just wanted to bring it to your attention. I imagine that your listing agreements are going to have to be changed to authorize the agent to sign on behalf of the owner. So that's something that needs to be done. And this form should be used just as a protection for you as a realtor. And I'll be happy to answer questions. You guys can always email me your questions with regards to this this document or any other documents that you may have. Does anybody have any questions?
Hi, Martha. Armando here.
Hey, Armando.
Yeah, I read it yesterday, and what I get from it, it's basically it's a release of liability from the listing agent, basically saying that, you know, it's a liability. Basically, somebody's going to sell the property. You're not going to get sued because the property, you know, they got a COVID-19 because the property was dirty, or somebody,
Sure.
or who's going to be accessing the property, that we're going to be able to meet all the government guidelines when you show it. So right now, everybody needs to wear a mask. That means that now, if you're going to show a property, if we're right now under wearing a mask order, that could happen anytime in the next few weeks, then that means that you're going to comply with those requirements, and also the buyer or the buyer's agent is also going to comply. What I wasn't sure about, and I think maybe you can answer this, is there any liability in which the property needs to be prepared, or measures need to be taken, you know, when you get a listing and you're going to show the property, that we have to tell the owner they got to get the property clean, or is there anything like that?
As a precaution, I would make sure, actually, when you're, well, from my understanding is when you show the property, it should be in its best condition, right? Because you're trying to sell it. So I would assume, and I would imagine that it has to be clean, in the sense that, you know, there's no, you know, the person who walks through the property is not necessarily going to be touching surfaces, but it should be, you know, swept clean and ready for someone to visit that property.
Yeah, but you may have a situation where you got a property that's vacant, you have a lockbox, and you have agents making appointments to show this property, and there's people coming in and out. And I think that document kind of like covers the liability part of it. As a listing agent, you can't make any representations that property, somebody may have gone in there and who's infected and touched everything in there, because we're not there.
Right, because you're certifying that to the best of your knowledge, that property doesn't pose any health risks, but it's to the best of your knowledge. You're not assuring that it is, you know, it's to the best of, and they're assuming the risk by entering on the property.
Correct. So they're basically taking the risk, and they're identifying.
Putting it on them.
Yeah. Okay.
So the suggestion is then to have, if we have a property that we're selling, to have the showing agent or the buyer in this case to go ahead and sign that form, correct?
Can you repeat that, Dylan? I didn't hear the first part of your question.
Yeah, the suggestion is to have, with a listing agent, to have the buyer and the other agent to sign off on that form, and that way we're not liable for.
Correct. That is the best practice right now.
Okay, all right, perfect. One thing we can do if we have properties that we're showing is perhaps we can put as an attachment on the MLS and make it a requirement for the agents when they want to show the house, then to go ahead and send us that over already signed. And we can do that as practice right now.
You know, Dailang, and I also think that that's a way where brokers can show that they're being proactive in today's market. When I deal with a professional, I want to make sure that they're always onto the latest news, that they're always with the latest information that's out there in the public. You know, it's just more professional, and it just gives a level of confidence in the professionals that you're using.
100%, yeah. Perfect. Thank you so much, Marta.
Oh, you're welcome. I'm always here. Whatever you guys need, I'm available. You can email me, or you can reach me at my office or on my cell phone. Thank you.
Did you say that you sent it out to all the agents? Did you send it to Steve, or?
I believe I did. Steve's on the list, and he should have received it yesterday. I sent out 2 email blasts, and I think I got 5 or 6 back, but I believe Steve was on that email blast.
Is Steve on? Steve, are you here?
Yes, I'm here.
Okay, so can you get that that form?
And it's on Form Simplicity also.
No, but I want to go ahead and send it to all the agents, everybody, because Steve is the one that really has the updated list. I want to send it to all the agents and make it a requirement for every listing that we have that it be signed. And also, as we move forward in showing the properties, I want all the agents to execute that document.
Steve, I sent it yesterday. Did you happen to get it?
I didn't see it, Martha, but I'll look again, and I'll email you if I need it.
I'll forward it to you, Steve. I have it. I'll forward it to you. Just send it in the through the Chime platform or however platform you want to send it through.
Yeah.
Great.
All right, perfect. Does anybody have any questions for Marta or Nicole?
Nicole, I have a quick question. I can't hear you. You there?
I'm here. Go ahead.
Okay, and thank you for all that information. This has to do with my mother. She has a will, and I know you don't want to talk about will, but I just have a question, so I figure I'm going to take the opportunity and see. She has a will from like 1980. Okay, it's one of these things that her and my dad. She's 90 years old. She's always worried about that. My sister and I haven't really, we haven't really been concerned about it, but she owns a property, okay, and it's my sister and me. Do you recommend basically a simple will, just signing that property in case something happens, so to prevent a probate situation, or you still have to?
So I'm sorry, I didn't mean to cut you off.
So do you still have to do probate, or could it be just a flat out will when you go in front of a judge and they just?
Yeah, the will really is just to designate how that property is going to be handled. So let's say in your mom's absence, it'll be distributed, half the interest to you and half of the interest to your sister.
Right.
If that's what the will says, then you have to probate the estate. That's all it's doing is designating the property. It's not actually giving you guys the title to it. So the probate process is really intended to pass the title from the title owner who passed, which eventually at some point will be your mom, to you and your sister, if that's how it's going to go. So one, if the will is still, I would say valid, it's still valid, but is it still applicable, right? Is it still the same property? Is it still how she wants to distribute? Or are there things listed in her will that don't make sense anymore, right? Like she doesn't live in that property or doesn't own that property anymore. Maybe it lists bank accounts that she doesn't have anymore that for some reason were closed. So first would be just to see if the will needs to be updated. And I'll tell you right off the bat, more often than not, if it has to be updated, you're just better off having it redone entirely. Right. And that's how most attorneys will do it, because to do an amendment to a will is almost more work than to just create a new one, okay? So that's number one. Make sure it's still valid in terms of it's still applicable. Not that the will is expired, it doesn't expire. And then the second thing would be to determine the best way to have the property pass. Is it only in her name now, or is it titled with someone else?
No, it's just her name.
Okay.
And that's the only asset that she has.
Yeah, so another way to avoid the probate process, but there would be like a capital gains or a tax triggering event, is to put one of you or both of you on the deed with her, right? So let's say she is now the sole title owner, and before she passes, she lists you or you and your sister on the title as well. I'm not an accountant, so I don't know exactly what that tax triggers, but you can't get around it. It's essentially something you'd have to pay at some point. But that would avoid the probate, because once she goes, then you're the single title owner on that, or you and your sister, however it may be. So that might be a way to avoid the probate. You would just have to double check with a CPA to understand the tax consequences to that. And then the other option is really a very simple, what we call a revocable living trust, an RLT. And we would title the property into that trust, list beneficiaries, just like we do in the will, saying you and your sister are the beneficiaries. And when the time comes to, for you to take ownership, we'll call it, or title of the property, it's deeded. It's through deed and through administering the trust. It's not through probate. And I'm getting a note here. Let me read what it says, because it might be applicable to what we're talking about. Is it better to sell before the person dies? I'm going to see a listing where the mother is on her deathbed and the son has the power of attorney. That is an option. Yeah. So avoiding the probate, if the property is only in one person's name and that person is, as you mentioned, on their deathbed, and it is sold before the person passes, and she or he has to have the capacity, the mental capacity to sign whatever documents are needed, then there's no probate. It's going to this new person, whoever the new person is, and if that person is still alive, then no probate issue there. Thank you, Nicole. The title to the property will dictate as to who will be signing the mortgage. If the persons on title are alive, there is no need for probate when you are doing a reverse mortgage. However, if any of the persons on title have passed and it is not held as joint tenants, then probate may be needed. It may be better for the person on their deathbed to sign a quitclaim deed. It could be. Again, there might be tax implications and capital gains that are triggered with that I'm not qualified really to discuss, but Judy, I believe, I would look into that. I can't give you a straight answer. Just like I said earlier in the comments, the very lawyerly answer, it all depends. She does not have the mental capacity, and the son has the power of attorney to sign at this point. So then for Florida, real estate transactions under a power of attorney is what we call a superpower. And as long as it meets the statutory requirements of how the power of attorney was drafted, so it's got to be actually a durable power of attorney, then there shouldn't be an issue. What I can tell you from experience is that title companies and financial institutions will give you a lot of pushback. They will try to avoid accepting the power of attorney for liability purposes. And that's usually where I'll get involved and quote some statute and basically tell them you either abide by this or I sue you. And then it usually gets things moving along pretty quickly.
All right, beautiful.
Did that answer your question, Armando?
Yes, thank you.
Okay, no problem.
All right,
Nicole, one thing as a side note, that a felon cannot be a personal representative.
Yes. A felon can't do a whole lot of things. I wouldn't be listing a felon as anything for anything, but yes, that's a good point. I've not had that come up in my practice. I've had a lot of other very bizarre things come up, but not someone trying to list a felon as a personal representative.
I've seen a will where mother has named both sons as personal representative, and one of them was a felon. So that a petition had to be sent in to remove one and take care of that.
Yep, that's absolutely right. When we petition for probate, we have to do a criminal affidavit, and we attest that the personal representative is not, a criminal, basically. So that's a good point. It's just such a standard, procedural thing for me that I don't think to call that out as something that's important. But Janelle, that makes perfect sense. So thanks for bringing that up.
Thank you, Janelle, for the comment.
Nicole,
Yes.
we have a client interested in purchasing a condo, and it says it has to be approved by the probate court. What do they mean by that? I
It
don't
prob-
believe there's any heirs.
Interesting. I can be the heir if they need me to. I'm kidding.
It's not worth it, I promise.
More headache than it's worth.
It's not going to put you, the IRS is not coming after you.
Gotcha. You know, I don't know if there's no heirs, and my guess is that someone passed and either heirs have not been located. And so because the person's no longer alive, you know, we can't buy and sell. It's got to be left to someone or the state, whatever the case might be, in order to move the property. So the only scenario I can think of is that the title owner of the property is passed, and if there's no one who's claiming it, right? If there are no heirs that have been located, then there's no one to pass it to in order to get an order to, or someone at least to administer the sale. I don't know if there are no heirs, then maybe that's what a court needs to do. Says, okay, we have a judicial finding that there are no heirs in this situation, and sure, we can go ahead and sell it. But I've not.
And then it just goes to, and then the proceeds go to the state.
Yes, and that's something I forgot to mention during my little presentation, is that when we're dealing with a title owner who's passed, the proceeds of the sale, they don't go to the heirs, the beneficiaries, even if it's clear cut who that person or those people are. It always goes to the estate, and the estate has a separate EIN number or EIN and its own bank account. So it does not go straight to the hands of an heir or a beneficiary. It goes to the estate itself and the account of the estate, and then we got to close out the estate and make the sale that way. Does that make sense?
Yes, thank you.
Yeah, no problem.
All right, guys. So if you wanna talk to Nicole, if you have any more questions or concern, she put her information on the chat. Please feel free to copy that or reach out to me or to her, or to me in this case, if you want to get her information. Once again, it's in the chat. You can call her at 305-699-2646, or feel free to follow her on Instagram at the Martens Law Firm. She has a lot of content, a lot of information she can share with you, and she'll be more than happy to help you out with any information that you need. Nicole, thank you so much for your help. Appreciate.
Thank you, guys. You guys have been great.
And Marta, thank you so much also for sharing. And guys, remember, and I talked about it on Monday, on Mindset Monday, that the people need you right now. Your neighbor needs you, your family needs you. People that rely on you, they need you now more than ever to step up and be a rock to them. So go ahead and be a leader. Be the leader that you can be, and provide the service that you can provide to the people, and surround yourself with professionals like the ones that participated today. Again, thank you so much for staying tuned with us, engaging. And again, thank you. Have a great Friday, everybody, and enjoy your weekend.
Dylan?
Yes.
Hi, I just wanted to mention, I saw something on the news last night that there's a Miami couple that started a website to track the PPP loans. So I'll go ahead and put that in the chat for everyone, and then I'll add it to our WhatsApp thread.
Feel free to do so.
Okay.
All right, thank you.
There you go.
And Daylon, it's Steve. I just wanted to make a plug too that next Thursday is going to be the Relevant Realtor virtual version with the COVID-19. So be sure to go to www.brokernation.events, register for that, invite other realtor friends and colleagues to attend that, and we'll be co-sponsoring that with Una, the developers in Miami. And be sure to check that brokernation.events for all the upcoming events and trainings that we have coming up.
All right. Thank you, Steve.
Thank you.
Very good. Bye, everybody. Happy Friday.
Thanks, Steve.
Everybody wave, please.
Weekend.
Everybody wave.
Bye-bye.
Thanks, guys. Everybody wave.
All right.
Bye. Good afternoon.
Bye, everybody.
Thank you.